Losing a job can be devastating, along with the loss of a steady income and health benefits. It can also make a big impact on a person's self-esteem. Our next guest is attorney Leonard McDermott from Employee Advocates. He has over 30 years experience fighting for the rights of employees facing anything from discrimination to wrongful termination. Welcome, Len. It's great to have you here.
Thank you, Jocelyn.
Now, you are an advocate for working people, both blue and white collar. But what exactly is employment law?
Well, employment law covers all the aspects that an employee can go through while they're working. Most of the time, the questions we get is about wrongful termination, loss of a promotion, or eventually unemployment.
Now, why did you choose to go into this type of law?
Well, I came from a working-class, blue-collar family, and I became a blue-collar worker myself, worked for the state of Connecticut, and I became a union representative. So it was natural that I just stayed with working for employees.
Okay, and you and I were talking earlier how when people call you, they're really very upset, and you see a wide range of emotion.
Yes, people call us and they're devastated. They're either crying, they could be angry, but they're scared. And the truth is that it's such a big deal to lose their job that they're looking for any kind of help we can give them, and we try to do that right over the telephone.
Are you getting a lot of phone calls, especially this tight economy?
Well, we're getting a lot of phone calls every single day, and especially these days, unemployment has raised a lot of unemployment appeals.
What rights do people have as an employee? First of all, let's talk about what an at-will employee is versus a contract or union employee.
Okay, this is a good point. Most people are at-will employees, meaning they don't have a contract for a period of time. For example, a union person probably has a contract that goes for 4 years. At-will person, you don't have a term on the end of it. That means the employer could be free to let you go for any reason or no reason at all.
Now, when a person is worried about possibly being fired, what should they be doing prior to that? Should they have a lot of documentation?
Well, I would say at the first sign that you're starting to get worried, it doesn't hurt to create some sort of a little logbook. If you do have emails on your computer, you should try to get them off of there before you get fired, because you may not have access to that later.
But obviously what it is that you want to do is you don't want to get fired. You want to keep that job as much as you can.
Right, and the problem is that most people aren't really free to negotiate as an at-will employee. So you have to really run a fine line. Better to call us before you get fired, because maybe we can give you some advice as to try to avoid getting fired.
Well, how do you know if you've been wrongfully fired?
Well, wrongful termination is similar to discrimination. There's two things that employers can't do: discriminate against you or violate statutory rights. But discrimination means that it has to be on the basis of protected class, such as age, disability, gender, sexual orientation, sexual harassment. You have to fall into a certain category. Otherwise, they're free to let you go.
But a lot of people don't understand that. That's very complex.
Right. Some people think discrimination means you're being treated differently than your coworker, or they like that coworker better than you. That's not discrimination.
What if somebody was also being harassed at work? How do you document that?
Well, again, keep your logbook. But most of the harassment calls we get are from what I call a miserable boss syndrome. Just because the boss yells, screams, swears, treats you horribly, it may not be illegal. It's not right. It's certainly wrong. But is it legally wrong? And to be legally wrong, it's the same type of classifications that you need for discrimination.
What do you mean by legally wrong? How do you know it is legally wrong?
There has to be some right, some law that protects you. For example, the classes of people I just talked about have been traditionally discriminated against for years. So eventually laws, state laws or federal laws, came into play that give them rights. And we have to see what are your rights. If there's no law, it's not legally wrong.
Now, how do you know when your lawsuit is a good one? Or how do you know that your case is a good one?
Best thing to do is we do a telephone consultation at no cost. Get on our website or just give us a call We'll do an intake, and the paralegals are very good at getting the information. They'll give it to me, and we'll get back to you and tell you whether we think we can help you or not. And sometimes we'll send people to certain state agencies, and there's no charge for that, too.
And what are your legal fees?
Most of our fees are usually on contingency, meaning we take a percentage of what we collect for the client. However, generally, in most cases, there's some sort of a retainer to go with it.
So there is some upfront cost for your client?
Normally there is. Certain cases, we're able to do that without the cost.
Do you have a sliding fee for folks who may not be able to afford it?
We work with the Connecticut Legal and Education Fund, and we definitely offer a sliding fee for any of the folks that come to us through there.
You're getting a lot of phone calls, as you said earlier. What kind of phone calls are you getting?
Well, you know, people are very concerned that they something happened where they lost their job, they don't know what to do, their employer's fighting their unemployment, they're losing, they can't pay the mortgage, they don't have health insurance anymore. Really, the loss of a job just impacts somebody in so many ways.
Fighting unemployment. Now, a lot of employers are doing that these days because they don't want to spend that extra money.
Right.
So how do you fight that?
Well, we fight through an appeal process.
There is an appeal process.
Yes, we have an appeal process, and we go to the unemployment office, and we prep our clients, and we put on like a mini trial.
What do you have to prove?
Well, we have to prove that they didn't really do anything wrongful that caused their firing, or that some cases that if they did have to quit, that it was for cause.
Is this a case that you usually win?
Quite a few of them. We can't win them all.
All right. If you want to get in touch with Attorney Leonard McDermott at Employee Advocates, the information is on the screen, or you could come to our website and click on Connecticut Style. We'll have that link for you. Len, thank you again.